good afternoon or good evening, wherever you are watching in the world. And welcome to this event to present Dr. Edward David's new book. Just a few housekeeping points that in this hour we'll be hearing from Dr. David, we'll be hearing from his respondents about the book. And there'll be a general discussion between these panelists. And then after that, there'll be an opportunity for questions and answers. Please look at the bottom of your screen where there's a Q&A button and use that to type in any of your questions. And during that time, at the end of this session, I'll be able to offer those to the panelists. Blackfriars Hall and the Les Casas Institute is very happy to host this event. I'm Father Bruno Clifton. I'm the Vice Regent of Blackfriars Hall. And first, I'd really like to welcome you and also to offer apologies for those who couldn't be here. The Regent, Father John O'Connor, and the Secretary of Studies, Father Robert Gay, offer their apologies that they couldn't make it here. But I'm sure they'll watch the recording after when they can. So, without further ado, perhaps I can introduce our speakers. First, we have Robert Matava. He is an Associate Professor of Theology and the Dean of the Graduate School at Christendom College in the United States, working at the intersection of philosophical theology, Christian doctrine, and moral theory. He's the author of Divine Causality and Human Free Choice, Domingo Banez, Physical Premonition, and the Controversy de Auxiliis Revisited. He received the Founders Award from the Society of Medieval and Renaissance Philosophy in 2009 and sits on the board of directors for the Fellowship of Catholic Scholars. Mr. Bertucio is the Avner S. Bar Dissertation Fellow at the University of Wisconsin-Madison in the United States, where he is finishing his doctoral dissertation in the Education Policy Studies and Curriculum and Instruction departments. Brett's research examines how American judges, curriculum developers, and educators understand church-state relations. Brett is a former fellow of the Religious Freedom Center in Washington, D.C., and his work has been published in First Things, as well as in numerous academic journals. And last, but of course not least, our main speaker, Edward David received his doctorate in theology and religion from the University of Oxford, studying under Nigel Biggar. He currently pursues a postdoctoral research fellowship in Oxford's Faculty of Theology and Religion, looking at the empirical and moral dimensions of character development for business leaders, in particular those leaders operating within the technology, legal, and financial services sectors. Edward holds a junior research fellowship at Blackfriars Hall and is a senior reader with the Canterbury Institute. He is an academic consultant for the Goldman Sachs 10,000 Small Businesses program and works in the growing field of law and religion. His new monograph, A Christian Approach to Corporate Religious Liberty, the focus of our presentation and discussion, has appeared this year. Future projects include the moral purposes of religious liberty and the issue of wealth inequality. In Edward's own words, through rigorous scholarship and research-based programming, I hope to promote human flourishing in business and society. Blackfriars Hall of the Les Casas Institute for Social Justice are delighted to welcome Dr. Edward David to invite us to discussion around the subject of his book, A Christian Approach to Corporate Religious Liberty. Thank you very much, Edward.
Father Bruno, thank you so much. I'm going to share my screen at this point, so just bear with me one moment. Can we see that okay? Perfect. Everyone, thank you so much for being here for this this book event, and thank you, Father Bruno, for the exhaustive introduction. Today, I'm going to give us an overview of certain aspects of my book, my new book entitled A Christian Approach to Corporate Religious Liberty, which really came out of my DPhil thesis here at the University of Oxford. Before I get started, however, I'd just like to reiterate thanks. Thanks to Blackfriars Hall for arranging this event, especially to Kinga, who's working behind the scenes to make all the logistics happen. I'd also like to thank Palgrave Macmillan, my publisher, for basically the confidence and trust in this work and getting it out to the public in such a professional way. Please feel free to keep in touch with myself, with Blackfriars, and with Palgrave via Twitter and other social media accounts. And of course, a final thank you, last but not least, to Brett and Professor Matava for their time and their generous comments and conversation coming up. So, and thank you to everyone who's here in attendance. So let's get started with this overview of the book. Now, here's my agenda for the next 10 minutes or so. I'm going to approach this overview of the book through 4 questions. 1, what is corporate religious liberty? 2, how might Christians think ethically about corporate religious liberty? 3, what difference does a Christian approach to this topic make? And 4, what about the church? How should the church be understood in a theory of corporate religious liberty? All 4 of these questions will be our focus in the presentation today, and they are central aspects of the book itself. However, the book itself is not structured so much in these 4 questions. Now, just to give some scope for the overview and also for the book, here's some points to keep in mind. 1 is that the book, no matter how great the title sounds in terms of like a marketing approach with which the publishers opted for, a Christian approach to corporate religious liberty, it may sound like this is great. Let's pick it up at Barnes and Noble or Amazon as like a public book, but it is actually deeply academic and not necessarily something you'd want to pick up for a light read. So it very much is an academic book. It's a niche entry into the issue of religious liberty for groups. And that niche entry is very much through the lens of the Christian tradition, looking both at ethical aspects in that tradition and also what I call or refer to as the group ontologies available within the Christian tradition. And I'll talk about group ontology a little later. Now, that niche entry, however, is meant to foster broader moral and theological reflection. So in a certain sense, yes, it's a niche and academic book. However, the implications of it are meant to be wide-ranging and to affect potentially public discourse on the issues around group religious freedoms. In terms of focus of the overview and of the book, I very much focus on the United States in terms of context. I also focus on free exercise disputes as opposed to establishment or church-state establishment disputes. Also, even though it is focused on the United States, the arguments that I make in the book are largely theoretical, again, looking at issues around moral theory, group ontology, and even aspects of ecclesiology. Now, it's also important for me to say that even if this book is now published and you can hold it in your hands if you want to dish out the money for it, it is still very much a work in progress. My thoughts there captured a moment in time, and I find that as these religious liberty disputes keep happening, right, because the Supreme Court is still dealing with the religious freedoms of groups even now as we speak. My thoughts on these issues still develop, and I'm really excited to have some 2 very rigorous thinkers with us today to help me and to help us think through that. So without further ado, let's jump into my questions structuring this presentation. So first of all, what is corporate religious liberty? Well, I'm approaching corporate religious liberty as a theory about the protections or rights of organized groups. Now this, the protection of organized groups in the United States around religious freedom issues has, of course, been very controversial. And Burwell versus Hobby Lobby, a Supreme Court case in 2014, is kind of a central case in this whole debate. So for those who are unfamiliar with Burwell versus Hobby Lobby, it basically involved a closely held family firm that objected to providing certain contraceptive services to employees. Now, that mandate to provide those services came from the federal government, came from the Affordable Care Act. So Hobby Lobby, the firm, eventually won out in the Supreme Court, and the court said, yes, the Religious Freedom Restoration Act, a federal statute, allowed Hobby Lobby to gain an accommodation to that contraceptive mandate, whereby they didn't necessarily have to supply or pay for those contraceptives for their employees. Now, that, of course, any case that's involving contraception and religious freedom in the United States is going to generate heated debate. And of course, it will generate a lot of literature and a lot of academic thinking over this. In 2016, an anthology entitled The Rise of Corporate Religious Liberty came out, which really helped influence my thinking around this topic. And I highly recommend it. In many ways, if you read my book, you'll see me critiquing lots of positions from the editors of this book who write the introduction to the anthology, and also to others in their chapters in here. But just to state up front here, in many ways, their work, even if I criticize it, there's lots of merit, and it has informed my thinking. So we'll talk about some of those points a little later in this presentation. I also want to highlight another academic work that came out that also touched upon corporate religious liberty, and that was Cecil Laborde's Liberalism's Religion. Laborde is also at the University of Oxford, and while she takes a more restrictive approach to corporate religious liberty, her liberal, and as in political liberal, approach to religious freedom is highly respected, and there are many points to wrestle with in her understanding of freedom of association. Now, my approach to corporate religious liberty really kind of takes issue with something I call an individual group divide. So on one side of this divide are those who really hold individual rights up as the normative touchstone of our conversations around group religious freedoms. And then on the group side of this divide are those who hold up groups as that normative touchstone, either defining groups in a very, and their protections in a very broad way, so allowing many different types of groups to hold religious freedoms, or even to the point of understanding groups as being metaphysical persons of a certain sort, and those metaphysical persons holding rights claims to religious freedom against others. So those are the kind of two extreme camps on this individual group divide. That individual side, often as the practical upshot of their theories, really want to restrict religious freedoms to strictly voluntary associations. And this is somewhere where Cecil Laborde would fit. Now, on the other side of that individual group divide are those, again, who would extend religious freedoms beyond strictly voluntary associations and let other different types of organizations, like for-profit firms, like Hobby Lobby Incorporated, enjoy those religious freedom protections. Now, my book finds the individual group divide useful, but also not too satisfying. It kind of plays into the polarization, or maybe it's a result of the polarization that we experience in the United States. So the way that I approach this is through this question. And I want to ask, well, to whom or to what does corporate religious liberty really apply? Or to whom or to what should corporate religious liberty really apply? Should it apply strictly to voluntary associations, meaning strictly to individuals, or should it apply to a wider range of groups? Now, I argue that corporate religious liberty in the book should apply neither to individuals nor group persons per se, but to the group actions of coordinating individuals. So I'm really trying to take an action approach or an action focus to this debate and trying to move the conversation away from individual right holders or group persons as right holders. Let's move to our second question here. So how might Christians think ethically about corporate religious liberty? Well, what I did is in one of my early chapters of the book, I go through how modern church statements from both the Catholic and Protestant traditions view religious liberty in general, view the freedom of the church, and then view what I call organizational exemptions, meaning the religious freedoms of non-church entities. And through an analysis of what these modern church teachings from Vatican II or from the World Council of Churches say, I basically draw out three principles coming out from these church documents. So one is a respect for religion itself, and religion being distinguished from, say, conscience. So religion being very much having a distinct definition and not being conflated with a modern secular understanding of conscience. Second, deference to a group's internal coordination. And to put that in more layman's terms, deference to a group's internal decision-making. Third, the third principle being that external interference upon that group's internal decision-making can be morally justified. Okay, and there's very few times where the churches in these documents really give absolute limits or walls to external interference. Of course, those limits are a bit more strong with churches or religious institutions, and we'll talk about that a little later. So those are three moral principles, if you will, that I found in an analysis of modern church statements on religious freedom. So let's bring this back to the book's core question, which is, to whom or to what does corporate religious liberty apply? Now, if these principles apply to mere aggregates, so individuals associating on voluntary terms, then what we get is, if that group is understood as a mere aggregate, then we will be protecting strictly voluntary associations. If we understand groups as moral persons, as metaphysical beings in and of themselves, in some strong metaphysical sense, then the principles that I've just outlined seem pretty unintelligible, right? Because those principles are very much dealing with actions, like the end of action being religion, the coordination of action with that second principle, and that third principle being the interference upon actions. Now, if you're dealing with a group person, the principles would need to be adjusted in a different way because you're not really dealing with coordinated action at that point. So is there a third way to understand what a group is, to whom or to what corporate religious liberty applies? And I say yes. So I look at Aquinas' understanding of what a group is, which can be found or gleaned in his treatise of human actions, actually. So towards the end of his treatise on human actions in the Prima Secundae, especially in Article 21. So in the book, I do an exegesis of sorts on that article, or question rather, especially the third and fourth articles. Okay, so what do I glean, or how do I interpret Aquinas' group as found in his writings, and especially towards the end of the Treatise of Human Actions? Well, so in my mind, Aquinas views groups as the coordinated actions of individuals, and he's viewing groups primarily from the perspective of moral philosophy. And so the subject matter of moral philosophy for Aquinas is human action, is voluntary human action, actions that humans can be held responsible for. And for him, groups are just the manifestation of individuals coordinating with each other towards a purpose, towards an end. So for Aquinas, again, from a moral philosophy perspective, a group is a coordination of individuals towards a purpose. And that coordination has two parts. There are the decision makers, or the authorities, and then there's the internal or coordinating public policy. And these are the procedures, the beliefs, the rules, the customs, the social mores that the individuals within this group follow in order to coordinate their actions, to coordinate their intentions to pursue an end or a purpose jointly, to intend that end together as a group. So again, for Aquinas, from a moral philosophy perspective, groups are social actions. Now, what's great about this group ontology, as I call it, this understanding of what groups are that Aquinas gives us, is that when we look at these principles from modern church teachings, which are focused on aspects of action, we can apply those principles to Aquinas's group. So here you'll see that first principle, respect for religion, pertaining to purpose, the second principle pertaining to the coordination of the group, and then the third principle pertaining to external interference or influences upon that group action. Okay, let's keep going. So what difference does a Christian approach make? Well, here's some key features. A Christian approach is organizationally inclusive. It does not restrict corporate religious freedoms to churches alone, but it does make a distinction between church freedoms, which are around religious actions, and a distinction distinguishing church freedoms from organizational exemptions. And so non-church groups, I understand as being individuals coordinating for secular actions or non-religious actions, and yet there is a religious motivation or intention behind those. Another difference of this Christian approach is that the focus is on the moral quality of social actions, and we're not so, in the first instance, not focusing on individual rights or group rights. The case Conestoga Wood versus HHS, which was a Third Circuit decision in 2013, Judge Jordan, who was part of the dissent in that case, check out his opinion, but it focuses on the function or the activity, the religious activity at stake, and not who are the First Amendment rights holders. Also, a Christian approach facilitates or encourages the responsible exercise of group religious action. It's not winner take all in the first instance, but it does create space for religious action, whether it's religiously motivated action or religious action distinctively understood, create space for that action to happen in society. But what this Christian approach is really asking us to do is to look at the moral quality of those actions and to make decisions from there. Now, real quick, I'll zip through these. What I do in the book, towards the end of the book, is I try to apply the theory to some cases. So I look at seal of confession disputes. I'm just gonna move there we go. So I look at seal of confession disputes, especially the Senate Bill 360 that attempted to be passed in California recently. And I make some prescriptions or some recommendations. So to not dictate the terms of social action, but to negotiate the settlement and safeguarding of children within religious institutions. Now, just some background information here. The seal of confession case and that Senate Bill 360 dealt with the California legislature essentially wanting to dictate the terms of how confession could work for Catholic priests. So they wanted to dictate the terms of how priests what they'd have to do if another priest were to confess an instance of child sex abuse to a priest. So the priest that heard that confession would be mandated by law to tell a government authority about that confession. So essentially what we see here is an external force, the government, trying to dictate the terms of the social action, that action of confession. I'm saying that's not quite an appropriate way for the government to approach the issue of child sex abuse. Rather, there's other ways to do that. So again, this Christian approach is trying to find other ways to bring about the good intentions that governments and society would like to see, but doing it in such a way that respects religious activity. I go through some wedding vendor cases, which are highly controversial, of course, towards the end of the book. And also at the start of the book, I look at some COVID restrictions. I'm not going to touch those there because Brett and Professor Matava will we'll talk about these, I'm sure. Very last point. Towards the end of my book, just going to put all of these up on the screen for us now. Towards the end of the book, I really want to focus in on another group ontology that I find in the Christian tradition, which I call strong group realism. And strong group realism, I argue, applies to the church alone. So if you flip through the literature on corporate religious liberty, you'll see some authors who maybe suggest that groups can be understood to have moral personality, and therefore they have moral rights. And the types of groups that they apply this to can even apply to businesses. And I say, maybe not. Okay, let's not apply the moral personality paradigm to businesses. I think that kind of complicates the moral discussion. Instead, I look at theological resources and pin moral personality, if that's a thing that exists for groups, I pin it to the church alone. I think Professor Matava is going to pick up on the supernatural personality of the church and what I say about that in the book. So I'll shorten my comments on that here, but I just want to point our attention to Justice Brennan's comments in this important case called Corporation of the Presiding Bishop versus Amos in 1987. That case basically involved a Mormon church's claim to hire staff on its own terms. Again, so it could have kind of the internal decision-making be not interfered with by the government. And what Justice Brennan says in his concurring opinion is this is perhaps the only instance that I found in Supreme Court opinions where you have a justice pointing to this group reality of the church or of a religious institution, a reality that kind of transcends the kind of mere aggregation of individuals. So he refers to a religious institution as an organic entity. Okay, so such a community represents an ongoing tradition of shared beliefs, an organic entity, not reducible to a mere aggregation of individuals. I find this to be a really interesting and morally relevant reference, right, to a theological belief that there is a group out there that is something that's more than the sum of its parts, but more than Aquinas's modest group realism, where a group actually is separate from its individuals, but yet is still reliant upon it. And this organic entity, I interpret Brennan addressing, is just something more. There's a supernatural person here. And we can look to the literature around the Corpus Mysticum, etc., to substantiate ideas around the supernatural person. So as a final point, just to summarize, 1, a Christian approach to corporate religious liberty is concerned with the moral quality of actions. 2, it values religion, it respects groups, and it involves the state. It doesn't preclude the state, but it actually involves it in some way. 3, it seeks discussion amid disagreement. so not winner takes all, but discussion amid disagreement. And fourth, it encourages moral and theological literacy, dipping into the group ontological resources of the Christian tradition, but also dipping into the moral teachings of the churches around issues on corporate religious freedom. And as a final point, the book ends with a stressing of the importance of virtue. So the book very much stresses practical reasoning, and there's a natural law paradigm working in the background. But at the end of the book, in the final chapter, I bring up the importance of the acquired virtues, prudence especially, and that virtue being very much necessary in discussion amidst disagreement. And I also bring up the reality of infused virtues as well. And those infused virtues coming from God and very much helping inform discussion from a Christian perspective on what should happen in these given disputes around corporate religious freedom. So I'll end there. Please check out my websites right there, the address. You can navigate to find the publisher's website to purchase the book. And yeah, thank you again to Blackfriars for hosting this event, and I'm very much looking forward to our ensuing discussion.
Thank you very much, Edward. So I'd just like now to hand over immediately to our first responder, Professor Matava, who will give us some insights into Edward's points. Thank you very much.
Thank you very much, Edward. It's a real pleasure to be with you, to be with all of you today. And thanks to Father Bruno as well, and to Blackfriars Hall. It's great to be joining you. It's been some years since I've joined with anything at Blackfriars Hall, and it's kind of a virtual way of reconnecting today. Also, Ed, I want to congratulate you on the publication of this fine work. I think you really deserve our applause for what you've achieved in your contribution. Let me begin with just a few positive observations on what I see to be some of the principal merits of Edward's work. And then I'll set out 3 arenas of questions. And I'm conscious of the limited time we have. We won't be able to engage all of these, but what I'll do while I have the floor is just set out a series of questions and as much as time allows, and then Edward and anyone else that wants to jump in, we can engage whatever is feasible with the time that we have. So I think that one of the most important contributions that Edward makes in his book is his appeal to moderate group realism, an idea that he finds in Aquinas. Relying on Finnis's explication of Aquinas, Edward's appeal to moderate group realism is helpful in 2 principal ways as I see it. First, it gives us a way of defending the idea that groups are entities in some real, moral, and perhaps even physical sense against the skeptical objection that group realism pits the existence and rights of abstract collectivities against the existence and rights of real flesh and blood individuals. The position of skeptics is at least prima facie plausible, and more importantly, has certain merit. However, it gains its plausibility from assuming a strong group realism, which Edward's view avoids. Thus, the skeptical objection appears to lose much, if not all of its force, against a position like Edward's. So I think that is a significant merit of his study. Secondly, Edward shows convincingly, I think, how Aquinas's moderate group realism can explain why certain secular enterprises of religious believers should enjoy religious freedom. While Edward is careful to distinguish the way and the extent to which religiously motivated secular enterprises, such as for-profit businesses established for the purpose of preparing material for the kingdom of God, should enjoy religious liberty, and he does this by focusing on the shared religious intentions of a secular enterprise's members, Edward gives us a basis for understanding that enterprise not as exclusively secular, but as religious in some limited but constitutive sense. This in turn renders the ascription of religious freedom to such an entity intelligible. So I think that that second point is also especially significant because it broadens the scope of our discussion of religious liberty, and it gives us some real insight into the Christian renewal of the temporal order. We're talking about religious liberty as it applies not just to identifiably religious groups, but to groups that are very much engaged in the world, businesses and things like that. Now, the questions that I'll raise and some of the challenges that I'll raise to Edward's work fall into three main arenas. One pertains to the modest group realism that you defend. I have some questions about that position. Secondly, some questions pertain to the strong group realism of the church and the supernatural personhood of the church that you defend. And then third, building on that, taking that a little bit more in the direction of the practical, which I know Brett will pick up. I have some questions about religious truth and civil authority and how we navigate the divide between the secular and the religious when it comes to substantive metaphysical claims about religious truth. So what are these questions? Well, in the first arena, having to do with modest group realism, the first question I have is why we should think that group actions, rather than groups themselves, are the proper subject of religious freedom. It seems, at least on the surface, like an odd claim to say that the subject of religious liberty is an action. I think it makes good sense to talk about group actions as constitutive of groups, and I think your study is very lucid on that. That seems, at least prima facie, very convincing to me. But then the further step to say that it's not the group constituted by the action in pursuit of a common good, but the action itself that's the subject of religious liberty. I wonder if you can explain and defend that a little bit further for us. A second question is an invitation to maybe expand what you did in the study to our reflections on civil authority itself. In your study, for good reason, you focused on the church and on religious secular enterprises as group agents or as subjects of religious liberty. But what about the state? Should we think about the state or civil authorities themselves as group agents? And if we do, does that help us in any way to balance the discussion? Does it relativize the prerogatives of the state or of the civil authority in respect to religious groups by allowing us to avoid a picture where it's the state and then maybe we have allowances for groups? Is it instead more of a dual spheres thing where we have two types of group and two types of group agency whose prerogatives stand in some kind of tension with each other? So I wonder if you could maybe say a little bit more about how to think about civil authority as in light of group agency. The second arena of questions that I wanted to raise concern the supernatural personhood of the church. And there's so much here to go into, but to put a succinct edge on it, my question really is, can't we have a strongly realist conception of the church without saying that the church is a person, right? So might there not be a way to apply a strong group realism to the church, which is really where you want to end up, as I take it? Can't we still get to the same endpoint that you need to get to without going so far as to say that the church is a person or the church is a supernatural person? I have some concerns about the reification of the church's personhood, and I'm not sure we need it in order to get the strong group realism that you need to have for your argument. And to sort of flesh out where those concerns are coming from, on the one hand, I think it's important to avoid a metaphorical understanding of the mystical body of Christ. And you brought that out explicitly in your study in really helpful ways, including by appealing to Pius XII, Mystici Corporis. But one of the things that Pius XII says there too, he even uses, and I don't have the article to mind here, but he uses the language of metaphor in talking about the mystical body. I think not to assert that the mystical body is merely metaphorical, but to forestall the opposite error, which is to collapse the distinct personhood of the members of the church into the personhood of Christ or into some kind of abstract personality of the church as a unified entity. So isn't there a middle course between a metaphorical idea of the mystical body and a view of the mystical body on which the mystical body is actually a person. My concern is that if we make it a person, what do we do with the idea of a church as communio? How does that not result in a loss of respect for the personal integrity of the church's members as a communion of individual persons? A second riff on that theme has to do with the Trinitarian background of these claims about the church. I noticed you focused heavily, with good reason, on Christ and on the Eucharist as constitutive of the church. A question that I had was, when we talk about the church as a person, or when you talk about the church as a person, who is that person? Is it a person of the Godhead? Is it some other person, a created person? It seemed that you were going in the direction of identifying the church with the second member of the Trinity, with God the Son made man. The church is constituted by the Eucharist, which is the real presence of Christ. But my mind was led in the direction of wondering about the Holy Spirit. You didn't say much about the Holy Spirit in your book, and yet it seems that it's the Spirit which vivifies and unifies the church. And if the church is an organism, really it's the agency of the Spirit that we need to look to as the principle of that organic unity that makes the church a whole, that unites the members not only with one another, but unites them with Christ, being the same one Spirit that makes Jesus the anointed one. So I wondered about the role that the Holy Spirit might play here, noticing that didn't come out too much. The last question in this arena that I wanted to raise leads into the next and final area, and that is, what about marginally sacramental forms of Christianity, or even non-sacramental religions or religious groups? You're obviously writing from a Christian Catholic theological perspective. You're doing Christian ethics, but you're making claims that have wide significance for the religious liberty debate in a pluralized liberal democracy. And so you make certain claims about the churches that in respect to other groups, the church stands out as having a strongly realist group. And you connect that in the theological foundations, that I mentioned. But what does this mean for other religious groups, other religions that are non-sacramental, or even other forms of Christianity that are sacramentally minimal, or which may have a much less corporately realist view of themselves? Christian communities that see themselves as voluntary organizations primarily, rather than a kind of metaphysically richer Catholic view that you espouse. So what are the implications of that for law in practice? Finally, the last area that I wanted to press on a little bit has to do with the relationship between, or the responsibilities of the civil authority in regard to religious truth. What are morally ambivalent religious practices? You bring this out at one point in your book to try to bring some clarity to when the state can intervene in the activities of religious organizations, whether those are secular or religious. And you say something to the effect, you can clarify this for me if I get anything wrong, that if there are religious practices or any kind of practices that are violations of the natural moral law, that are morally questionable, this gives the state some prerogative for intervening in order to defend the rights of the individual members of that groups or others whose the group's actions bear upon. But if the religious activities are morally ambivalent, the state doesn't have the standing or the prerogative to intervene. And my question there is, what exactly are morally ambivalent religious practices? Are there morally ambivalent human actions at all? And if the answer to that is no, how does your view negotiate the divide between integralism and religious indifferentism? How is the state not committed to answering substantive metaphysical questions having to do with religious truth? Is the state obliged to take a position on substantive religious claims or not? And finally, last of all, why should the state recognize the strong group agency of the church? I can see why Christians should think that the church is a strong group agent, but why should a secular civil authority acknowledge that? And that's kind of a particularization of my broad question about how the state has to define itself in respect to substantive religious claims. Thank you.
Well, thank you very much for raising those questions. I'm sure get people thinking of their own, and a lot to think about. So immediately just want to get the input from Brett Bertucio on perhaps some more practical issues and implications of these ideas. Thank you.
Thank you so much, Father Clifton, and thank you. I just want a big thank you to Ed. I was just delighted to be invited, and really a pleasure to dive into your work. And I'll be in quarantine, walking around my house thinking about group ontology for weeks now. But so my field of study is a kind of American historical civic education and jurisprudence around religion and education. So I just wanted, for the sake of time, to bring up one practical problem and see how Edwards' theory might enlighten us or provide insight. And just for folks in the UK, kind of a brief overview of the educational ecology here in the States. So the big distinction in educational institutions is between public schools, which doesn't map onto the what we would call a public school in the UK. So a public school in the US is state funded and state operated, is free of tuition. And then there's private schools, which receive no money from tax revenue typically. There's kind of marginal places where they do. And these, a lot would be religiously affiliated and are fee structured or charged tuition. And so the Establishment Clause of the First Amendment has been interpreted over the last 60, 70 years to mean that tax revenue cannot directly fund religiously affiliated schools. So I kind of want to ask about a series of cases that have come up recently in the Supreme Court about this. So one kind of category of cases is about state aid that flows to religious schools. So there's a recent case, Espinoza v. Montana, that was decided at the end of June. And basically the state of Montana granted a tax credit to individuals who donate to a scholarship fund, which in turn grants tuition money for low-income students to attend private schools. And so the state of Montana said, because of a piece of the state constitution, that tuition money could not eventually flow to religious affiliated schools. But we have this kind of convoluted way in which money flows, in part because, and I think Edwards' explication of theories of group ontology was so helpful, and because American law, for the most part, has an elimination theory of group ontology, meaning that a group is simply the aggregation of individual interests or preferences. And in American law, these sorts of, we call them school choice programs, whereby tax revenue can flow eventually to a private school, are predicated on what's called child benefit theory. And it's basically the idea that a religious educational institution is simply the aggregation of parents' preferences in education and has no sort of being or rights on its own. And so there's a lot of kind of sticky questions that come up because we have this, say, flat group ontology, or what Edward refers to as an individual group divide in the jurisprudence. And so I'm really hopeful or wonder that if we can take up Edward's definition of the subject of corporate religious liberty as group agential actions, then we might see that schools, for instance, should be considered a legal entity in their own, and then are privileged to legal rights of religious liberty. And it might open up the space for kind of a legislative regime or a legal regime that might more resemble what's the case in most European democracies, where the government might assist financially religiously affiliated schools. Another case, and I feel like the most interesting questions come up here, and I think education is a really great case study for some of Edward's theory, because schooling and learning kind of sits on some of the boundaries of the conceptual distinction he draws. So this case was decided, I believe, last summer, Trinity Lutheran v. Comer. And it's predicated on a conceptual division between secular and religious activities within one religiously affiliated organization, and what has come to be called in the jurisprudence the status-use distinction. So basically, a summary of the case, the state of Missouri has a block grant program. If you run a preschool, you can apply to the state and you get recycled tire scraps for your preschool. I don't know if you've noticed these on playgrounds. So a Lutheran preschool applied to the program, and the state said, we cannot, because of our state constitution, we cannot refund religious activity. So because you are a Lutheran preschool, you can't get the tire scraps. And so the school sued, and eventually the case reaches the US Supreme Court. And the court's reasoning was this, that the preschool was denied an otherwise public benefit because of its religious status. But the courts kind of struck down Missouri's reasoning. But the court said this withholding or rejection of the right might be appropriate if the grant was being put to religious use. And so we kind of have this, Espinoza was also kind of predicated on this distinction between the status of an institution as religiously affiliated, or the use or activity that funds might be put to. Are they put to a religious use? And of course, Edward's theory is kind of built on agential actions, so a use distinction. And concurring in this Trinity Lutheran case, I want to point to some of the language of the justices. So 2 justices concurred, but they said the status-use distinction is false, or at least unclear. And so this is from Justice Neil Gorsuch, with whom Justice Clarence Thomas joined. He said, respectfully, I harbor doubts about the stability of such a distinction. Does a religious man say grace before dinner, or does a big man begin his meal in a religious manner? Is it a religious group that builds this playground, or did the group build the playground so as to advance a religious mission? In dissent, Justice Sotomayor raised a similar objection, and so she said she would uphold the exclusion of the school from this public program as, and these are her words, the playground surface cannot be confined to secular use any more than lumber used to frame the church's walls, glass stained and used to form its windows, or nails used to build its altar could be confined to secular use. So I think this status-use distinction is an interesting test case for parts of Edward's theory. So Edward distinguishes 2 analytical procedures for, one called freedom of the church. So for, we might say a house of worship or something we can easily define as religious. And then a separate procedure for organizational exemptions. These would be religiously inspired organizations, and I would take schools as part of that. And so this delineation depends, in Edward's theory, both on the diversity or homogeneity of the members of the group, as well as its aims. And so Edward kind of has a category of religiously motivated secular actions. And so my question in the case of Trinity Lutheran, we have an educational institution that seems to have multiple aims. Certainly they're catechizing students in a religious faith, and Edward kind of agrees that this is a properly religious activity, but then they're doing things that we might classify as secular. Let's say a non-preschool, an institution of elementary or secondary education is teaching mathematics, for example. And we might say, oh, this is a secular purpose or aim. But then we might say in a religious or a Christian affiliated school, one might have a lesson example in the mathematics class about natural harmonics and how this can kind of give us a sense of the intelligibility of the created order. And in a certain way, I'm trying to inculcate students into a certain religious tradition. So the question becomes, in the case of a school, seems to have multiple activities. On the school's part, I would imagine that this Trinity Lutheran Preschool or other religiously affiliated schools would say that all its activities are part of a coherent whole whose end is obviously religion. But the court here says is upholding their rights as religious organizations based on kind of an imposed division of their activities into religious and secular. Religious, which the state might not be able to support, and secular, which it does.
Could I just remind, sorry to interrupt, very sorry to interrupt, but just to say that this is 4 minutes to 6 now. So we've got kind of, so maybe just to kind of be able to have get Edward to bring some answers to this.
Yes, so I'll end with my question. Sorry. Yeah, no, this is phenomenal. What do you do with an institution that seems to bridge lines or seems to have multiple activities? Thank you very much, Father Clifton and Ed, for the invitation.
No, thanks. So sorry to have to cut you off. It's all very interesting.
No,
so if you'd all like to perhaps bring Edward in and then see how we can resolve some of these issues. And we have a great question as well. So let's see how well we do with the time we have.
Great. So, wow. Both, thank you so much for your thoughtful responses and really rigorous questions that I answer in different ways in the book, and I'm not sure I can answer thoroughly and up to snuff here and now, but I'll try to touch upon some points briefly, if that's okay, from your various set of questions. So first, dealing, well, what do you do with a group that has multiple purposes? In a certain sense, I would say that a theory of organizational exemptions could be applied to religious institutions as well, actually. So while I make the distinction between these two types of religious regimes or religious protection regimes, I would keep the freedom of the church for churches proper as a kind of central case study. So that would be the most robust form of group protection, would be a church. Now we'll get into a discussion about what a church is a little later. But then organizational exemptions, I would apply to anything else. So even a religious school could apply to that. But the central feature of organizational exemptions is that, yes, there could be more room for restrictions upon what that group can partake in. However, even if you were to define a religious school as a church, I would still probably apply an organizational regime, exemption regime to that. Much more to say on that topic, but I want to get to some of Professor Matava's questions here too. I think the key question that comes out for me is, why say that the subject matter of religious liberty is action, as opposed to the individual or group themselves? And for me, that's at the core of the book. And I think the rationale behind this is to really bring the discussion around religious liberty back into the domain of ethical reasoning. And in my mind, where the debate around religious freedom has gone to is a kind of a very abstract discussion that has been influenced by these abstract legal doctrines, for example, that Brett was mentioning around like child benefit theory and status use distinctions, etc. Those sorts of abstractions, I understand the use of them for jurisprudence reasons and how these have come up through court cases. However, I think there is a danger when we let legal abstractions kind of dictate the terms of our ethical thinking. And the notion of group moral personality is one of those legal abstractions, right? So the idea of legal personality applying to a group, a corporation in the first instance, that has, in my mind, affected our our ethical thinking on these topics to a distracting degree. And I think that's something that the editors of that book, The Rise of Corporate Religious Liberty, Michael Schwarzman, Richard Schrager, etc., all touch upon, and Cecil Laborde. And I agree 100% with that. So the point of bringing religious liberty, the subject matter, to action is to try to kind of respect the purity, if you will, of, what is the subject matter and method of moral philosophy? Well, it is around action. And the method follows from that, right? Don't let the moral philosophy be driven by issues around abstract legal concepts like legal personality. So that's really at the heart of what the book is getting at, and that's why I take that position, or as the group ontology and the action form of that, the modest group realism, as that starting point. I see, Father Bruno, that there is another question that you wanted to ask. Should we get to that real quick, and then?
I think so. What's very good is we have one great question in the question and answers, which is actually beneficial so the time can be very succinct. So if you feel, because all the panelists can also see this question, it's a question about, rather than focusing on the US, about the English situation of an established church. In which case, does it neutralize religious corporate liberties in the public space and before the courts? Because the state can say the state is already responding to religious liberty as the church, an established church, a moral and religious entity, because it's already incorporated into the state. And in this case, the question queries whether the British Supreme Court would rule in the same way as the US did for the hobby lobby case. So that's the question for everybody.
Yeah, so as a first step to this, and I think it may also, my answer would get to some of Professor Matava's final set of questions around the state's role in recognizing strong group realism, for example, the idea that the church is a supernatural person, which might have some claims, is in my approach to corporate religious liberty, I take a very, in a certain sense, like a agnostic approach as to the degree to which the state itself adopts religious precepts as part of its moral decision-making. Now, of course, the impetus or motivation of the approach is to encourage theological and moral literacy. And not just starting at the state level, but really coming from the churches themselves, inculcating virtue amongst congregations, and really transforming society and our discourse around corporate religious liberty from the church outwards. And that's a point that I try to make subtly towards the end of the book there. But I leave flexibility around, whether the state takes an American separation, kind of Jeffersonian separation of church and state. There's this wall between them. Whether the state takes that approach or whether it takes an established approach to these corporate religious liberty issues. Do Brett or Professor Matava have any thoughts on establishment questions? What would happen if the state did have an established religion? How would these issues play out?
This is quite interesting. I guess I would maybe respond with another question. I wonder if the American society or American legal system does have an established church. It's simply not named. And we have your theory kind of organizational exemptions is necessary because the state is taking moral positions, and I would argue theological positions, and certain organizations differ in their conceptions. So I wonder if the jurisprudence would not be all that dissimilar. We would simply have to compare kind of the stated moral claims of the Church of England with those of the religious organization in question.
Yeah, no, I think you make a good point, Brett. And in my book, one of the sort of assumptions underlying the theory, this Christian approach to corporate religious liberty, is that the state can hold a normative position. And it's not just that it can, but it actually does. And so what I get at is that let's not kid ourselves. The state does have a normative position, and part of my argument is that, well, if in public discourse religious beliefs can be voiced and proclaimed, as as some political liberals today want to say, right, in kind of response to Rawlsian, a more restrictive understanding of public reasoning, that religious ideas can be put out in public. I'm going, well, let's recapture those ideas. Let's look at the group ontology around what groups are. Let's look at understanding the church as more than the sum of her parts, etc. And all of this informs moral reasoning over the scope and the limits of group religious freedoms.
So, Edward, is your view then that the state can't avoid staking out a position on substantive religious questions? Is your view that happens de facto, and that it's to be welcomed, or it's unavoidable at least? And how does the state approach these kinds of questions? Are you committed to integralism then, or do you think the state can deal with these questions yet avoid a kind of integralist view of its role?
Yeah, no, that's a great question. Again, so while I admit that the state can pick up this, take up a normative position, right? I do again leave room for what the practical upshot in terms of a religious liberty regime might look like. So again, it could be separationism. It could be a really strong form of integralism, some establishment, and what we think of with integralism as it's proposed in some circles today. However, that said, I'd say that my approach that I'm articulating in the book really wants to leave room for that, the dignity of the individual search for religious truth as well, because that is something that I see in the modern church statements from Vatican II, from the World Council of Churches. And I think if we were to take those principles seriously, what we see in those church statements, I don't think we would have a very rigorous kind of middle, what some would imagine would be a state in the Middle Ages in Europe, this kind of romanticized integralism. I don't think we'd see that with modern church statements on religious freedom. So in a certain sense, my book is a product of its age. It's a product of my, academic background and beliefs as well. And there is room for political liberal ideas here, and respect for the individual search for religious truth. And just to add, secondly, a friend of mine who read an early version of the manuscripts made this comment, and he said, "It looks like you don't really know what religion is." And it's because I take a multi-tiered view of what religion is that I take from Aquinas and from the natural law tradition. I think we can think of religious liberty as just the search of questioning for a search for answers of questions of ultimate significance. I think as a baseline understanding of religion, you can take that and use that in this Christian approach to religious liberty. But I think you can go beyond that, and you can go to religion understood as, well, now there's answers to these questions. There's a divine source answering back to my questions about ultimate reality. And that's another tier of religion, or another understanding of what religion could be. And then additionally, if we look to the Summa, we have Aquinas defining religion as a moral virtue, as a subset of justice. And if it is a moral virtue, then to your point around Christian renewal of the temporal order, we have people's religious beliefs, right, being infused in their ostensibly secular activities as well. So
thanks very much, Edward. No, I
yeah.
just really feel now we have to, unfortunately, bring the webinar to a close, really. We've run out of, or gone over our allotted time. We had another great question, which I'm sure you can read yourself, and maybe it will give you food for thought. But I'd like just to thank everybody who attended in these difficult times. It's really good to actually note that there's some positive things that can come out of our separation in the global pandemic, which is discovering these new technologies and enabling this type of discussion even when we're in different time zones and in vastly thousands of miles from each other. So thank you very much, everybody, for coming, and particularly thank you to the panelists for joining us. And I must say to the Las Casas Institute and Kinga, who's behind the scenes working everything. So I'll say goodbye to everybody, and thank you very much for attending. And thank you, Edward. Congratulations on your book.
Thank you, everyone, for coming.
Thank you very much.